Parties may be seated.
Thank you, ma'am. We're here today. I don't know whether you've received our vessel. It was served at 5 o'clock, well, 4:45 last night through the court clerk.
Mr. Swartz?
Yes, ma'am.
I think you need to wait for a moment until I address you, please.
Ma'am, we are here. Our argument and contention is to
Sir, I have a couple of remarks, if you don't mind.
Yes, ma'am. I was hoping to finish my objection.
Just hold it for a moment, please. This matter is set for trial on the 7th of November. The court is in receipt of a late in the event motion received from the defense as of yesterday at 4:40 p.m. Ms. Kuhn, what is the position of the state at this time with regard to the protocol on this case?
Well, as the court noted, I received the motion from the defense as well. I had the opportunity to review it this morning briefly. As for the request for discovery, my office will get that out as quickly as we can. And for other aspects of the motion, the state would need more time to actually look into it. Maybe some of the stuff in the motion is actually civil related and is not actually related to the criminal case. So I don't want to take a position yet on the actual aspects contained in the motion.
Objection, Your Honor. We're here to challenge the jurisdiction of the court as our vessel stated with the federal postage stamp on it served yesterday. We do contest the fact, I just recently last week received your oath of office, ma'am, and I observed that it was not in correct parse, syntax, quantum grammar. So, as I am not familiar with you, Your Honor, we contest the fact I would like you to be disqualified, and if this is to proceed forward, that a seated judge with a perfected quantum grammar, parse, syntax oath of office be allowed to hear this case. At the present time, the state does not prove jurisdiction. Paperwork does not prove jurisdiction, ma'am, and I would like to put in a verbal motion if you would like to contract with Mr. Barnett and I in an unofficial capacity to discharge this today in an expedient manner, as the state in a timely manner has failed to state a cause for which relief can be granted. They've failed to prosecute. I don't know what the problem was with me having to wait until last week to get your oath of office, ma'am. And then once we received it and checked it out with the parse, syntax, grammar. So if there's anything done here today, ma'am, we would like to be the moving party, and I, acting as a private attorney general, if you are willing to contract with us, ma'am, and make a discharge of this matter, we would not have a problem with you invoking malum in se today. If not, if this court would like to try and move forward without proving jurisdiction on the record, and I do realize this is not a court of record, ma'am, and that is a possible point of contention also. We merely posted the federal form to the courts to challenge the jurisdiction and not violate the decorum of the court, ma'am. So at this point in time, if you would like to contract us to dismiss for failure to prosecute or prove jurisdiction, which geographic location is not a description for jurisdiction. And I believe it would violate my client's, and I use the term client meaning friend here. That's my glossary of terms. I receive no monetary remuneration for my services, ma'am. Mr. Barnett is merely a friend. And we would like to handle this matter expediently today, and if you're willing to dismiss, we would contract you and your authority to do that. But if not, we would like you to just We would like the court's record to reflect that, not that you have a conflict of interest or anything, ma'am. I am not suggesting that. I would just like a judge to preside over this with a true parse simtac grammar oath of office so that we might enforce the viable contract. Thank you, Your Honor.
So if I understand you correctly, Mr. Swartz, you'll agree to recognize my authority if I dismiss the case, but if I don't dismiss the case, you will not recognize my authority. Your motion is denied.
Objection, Your Honor.
I am speaking. Do not speak.
I am objecting, Your Honor.
I am speaking. Mr. Swartz, have a seat.
Please, may I?
Have a seat.
I prefer to stand.
If I could finish, Mr. Swartz, we'd be done a lot quicker. Have a seat.
May I please stand? Yes, I'm trying to be compliant. Please speak, ma'am. I do not wish to violate the rules of the decorum of this court. Please
thank
speak.
you, because you're skirting the edge. Now,
Yes.
if you wish to assert your right to transfer this matter to the Circuit Court for Douglas County for purposes of the case being in a court of record, I will give you leave to do so. Written notice is required to be in the hands of the court clerk within 10 days. Failing the receipt of that notice, this case will proceed to trial or a de minimis hearing that morning of November 7th. That being said, Ms. Kuhn, did you wish to address any of these remarks?
Objection and clarification, Your Honor.
Sir, are you Ms. Kuhn? Ms. Kuhn, do you have anything to say?
Is this court restricting my ability on and for the record to
I asked
object?
Ms. Kuhn for a response. Would you please allow her to respond?
Thank you, Your
Ms.
Honor.
Kuhn.
To move forward would violate my objection, Your Honor. To acquiesce in law.
Mr. Schwartz, I allowed you the opportunity to speak, and I would appreciate you if you would allow me to conduct the matter. So, please.
Ma'am,
take a
please let
breath.
the record reflect that I am feeling very intimidated by your refusing my objection. Once I give up something, we can't unring the bell, ma'am. And that was a point of clarification. I was not trying to interrupt. I was merely trying to do my due diligence.
You're not trying to interrupt, Mr. Schwartz.
I'm
but it has
objecting,
that
you're right.
effect. I listened to your statement. I'm looking to allow the state to respond to what you have said. I will be willing to listen to both sides, but you have to allow me to conduct the matter. Ms. Kuhn, do you have a response?
Just briefly, Your Honor, I agree with the court that Mr. Swartz and Mr. Barnett want this to be in the court of record. They can file a proper written notice. Not to address jurisdiction. If the defense would like to file a proper motion to test jurisdiction, then that can be done, and then we can have a hearing on that. But the things that were put in the motion that was submitted involve civil jurisdiction, and that was not part of it.
Objection on and for the record in rebuttal to the Deputy District Attorney's statement, Your Honor. She has no standing here today at all. She cannot even be allowed on the record to speak here today because she has not proven jurisdiction. Jurisdiction can never be presumed. It must be proved. And waving a piece of paper and talking over a box is not a live human being here proving jurisdiction. So I would make one more verbal motion, ma'am, that this be dismissed, not that we contest or not that we acquiesce that you have jurisdiction over this, because we still contest, and our original point of objection was that you do not have a viable quantum grammar parse simtac oath of office on record with this court. And I mean no disrespect, ma'am. I do not know you from anyone. You don't know me. And my ability here to protect and preserve his rights to due process, the Deputy District Attorney has proceeded forward violating my client's federal due process of laws in due process by moving forward with this case without proving jurisdiction to you or anyone else. Thank you, Your Honor. Motion and honorable demand for dismissal. The state in a timely manner has failed to prove jurisdiction or state a claim which relief may be granted. And we kind of like to have Mr. Barnett's property returned to him?
Are you quite finished?
That depends on, ma'am, on what is spoken after this. At this present time, I would like to request that you be disqualified as a judge in this matter.
Mr. Swartz, you've repeated yourself several times. I understand your point of view. And with all due respect, repetition does not give greater weight to your statement. So please, pause. Ms. Kuhn, do you have anything further?
No, Your Honor.
Thank you. All right. I have already denied your motion, and that decision stands. Now, as I said previously, you may certainly transfer this case to a court of record and have it heard by a judge in the circuit court for Douglas County. You can have the motion heard by a circuit court in Douglas County. That's absolutely the right of the defense. And we will wait to see whether or not that motion is filed. This court is not prepared to address your motion with regard to the other issues raised within the motion that was filed shortly before the office closed last night. That motion did not hit this desk until early this morning. The state is prepared to release discovery and has said that they will do so with all speed, and then that will give them an opportunity also to review the rest of your motion.
Please let the record...
Sir, you had time to prepare your motion. I am allowing time for consideration of it.
Objection.
Therefore, this matter is continued for the 10-day window in order for you to seek transfer to a court of record where these issues can be heard by a judge with whom you express confidence.
Objection and point of clarity.
I understand that you are not pointing any fingers at me as a person, but I also understand you have concerns that you have expressed.
I don't consent.
That is my decision, Mr. Schwartz.
Ma'am,
and this proceeding is completed.
Ma'am, I object in clarification. You have not...
I understand you object.
You have not, on and for the record, ma'am, you have not produced a viable oath of office to exercise any authority here in this matter, ma'am. Will you please not...
I'm giving you an opportunity to speak,
and
I have listened.
You are interrupting.
These proceedings are adjourned.
I do not